Yes, Your
then.
Honor.
All right. My question to you, is there any mention or evidence of this $10 million in the evidence presented before this honorable court?
Objection, Your Honor. Up to now, the witness has not been qualified. With due respect, the mere fact that the ombudsman...
The counsel for the prosecution is correct. Just to help in this, anyway, this is a preliminary matter. Madam Ombudsman, you are conducting an investigation of this case against the respondent. Am I correct?
Yes, Your Honor.
And then,
fact-finding investigation, Your Honor. Case build-up,
fact-finding investigation.
as opposed to preliminary investigation, Your Honor.
Have you made any findings at all
About,
against the respondent?
well, I was able to get data showing that at
You
least
obtained material, data material to
material and relevant to the
complaints
filed by the
your
three
office.
complainants, yes, from the at least from the first
And are
complainant.
those materials adverse to the respondent?
Well, it appeared so, Your Honor, because these are the documents that I sourced.
So that
From that
whatever
agency.
testimony you will give here in this court would have the tendency to be adverse to the respondent.
It appears so, Your Honor,
All right.
and that is the reason
Counsel,
why.
proceed.
In which case, Your Honor,
If you want to make a motion, then make a motion.
May we move, Your Honor, that the witness be declared as a hostile witness, Your Honor, because her interest as ombudsman investigating the case is already adverse to that of the respondent, the Honorable Chief Justice
With the
Corona, Your
answers
Honor.
of the...
Your Honor, that is my mandate. If I am mandated by law to investigate, and I investigate the respondent, that does not make me an adverse
Yes.
person.
if
So I had to discharge my mandate.
That's correct. That's correct. That's a constitutional mandate. In fact, the
Leave me
ombudsman
alone.
can investigate with or without complaint.
That's right, Your Honor.
So,
But, so,
you may proceed.
yes, Your Honor.
If Your Honor, please, the defense has moved for the qualification of the witness as a hostile witness. May I object? The mere fact that the ombudsman is conducting an investigation does not render her as an adverse witness. In fact, she has merely written the Chief Justice to explain if there is any truth to the allegation that he has $10 million. There has been no adverse finding by the ombudsman. She is merely performing her mandate and task under the Constitution and the ombudsman's law. That is not evidence of any adverse
There is
interest.
we do not question that there is an investigation, that the investigation is allegedly being conducted by the Honorable Ombudsman, Your Honor, pursuant to law. What we wanted to lay down is the fact that there is already allegedly a finding made by her adverse to that of the Chief Justice. How can she be expected to be neutral, to be unbiased, and to be impartial, Your Honor,
if I
in
may
the dealing with the Chief Justice, Your Honor?
The ombudsman has not said she has made a finding. She merely said that she has gathered or received data. She has not made any finding.
Precisely the gathering of data do not appear to be in consonance with the impartial investigation of a case, Your Honor. Because there are complainants in here. This
All
is
right, to cut short this discussion, unless I am reversed by the impeachment court, given the fact that the ombudsman, according to the question of the counsel for the defense, has shown some disagreement with the respondent, and the fact that she is the one investigating the respondent by virtue of her office, this court would consider her as a hostile witness and so declare that she is hostile witness, and you may examine her as a
Thank
as
you,
a
Your
hostile
Honor.
witness. Proceed.
now. Being a respondent in your case, his position may be akin to that of an accused in a criminal case. Am
I
right?
said, Your Honor, we're still in the fact-finding investigation. He was a mere respondent. you become an accused only when you are indicted in court.
I'm not saying he is an accused. He may be likened to an accused in a
Well,
criminal case. There is no similarity whatsoever. Is that your point?
Well, as I said, it's merely fact-finding.
Yes,
There
but-
is no determination yet of probable cause because he has to undergo preliminary investigation. If we wind up our fact-finding investigation and we believe that there ought to be preliminary investigation, then we set the case for
But why,
preliminary.
why the necessity of compelling him to submit or to file an answer?
That is what the law says, Your Honor, Section 26.
But this is practically compelling him to be a witness, which is prescribed by the Constitution under Article 3, Section 17.
Are you assailing-
That no person may be compelled to be a witness again. Because the moment she answers, necessarily, she has to state his reason.
Are you assailing the constitutionality of Section 26? Of
I'm
the
raising it right now because it's a
Objection, Your Honor,
practice.
please.
It does not follow, Your
The-
Honor,
the-
that if he refuses to answer, then he should...
Counsel,
I'm still...
please propound your question.
Yes.
Do not argue with the witness.
There is a pending question, Your Honor.
Yes, precisely. Ask
My question-
your question,
My question, Your
whether
Honor...
leading or direct question. You're now entitled to ask, but do not
Yes.
argue with the witness.
I'm not, Your Honor. I'm asking her, Your Honor, whether the position of the Chief Justice as a respondent or a party being investigated with her office may be compared to that of an accused in a criminal case.
You are asking an opinion.
Yes. Well,
That is a legal characterization.
but
We are dealing with facts here.
she is very much in a position to answer that.
Well,
Your Honor, with
the
due
ombudsman
respect,
may answer if she wishes to answer.
I didn't
I
get-
have already answered,
Yes.
Your Honor.
All right. And in accordance with the Constitution, the law says, under Article 3, Section 17, no person may be compelled to be a witness against himself.
I did not compel him, Your Honor. I said I was just following the mandate of the law. That was his lookout. If he did not like to answer, he could waive answering if he wanted.
Yes,
But again, as I'm saying, Your Honor, you are assailing the constitutionality of Section 26.
I'm showing that that practice is not in accordance with the
It
Constitution.
is
Your
not
Honor,
a practice,
because-
Your Honor. It is a provision of law. Section 26 of the Anti-Graft and Corrupt Practices Act.
Yes, but
Oh.
that nullifies the right of... I'm sorry. I'll just ask question. I'm sorry, Your Honor, and I apologize. Now, furthermore, may I direct your attention to this portion of...
Sorry.
your
Let me
letter to the Chief-
correct my answer. This is not Section 26 of the Ombudsman Act, not the Anti-Graft and Corrupt Practices Act.
Counsel, may I remind you that the time to raise the non-incrimination clause of the Bill of Rights is when a question is addressed to the respondent. She was only asked to appear for
To answer, Your Honor.
To answer, Your
to
Honor.
answer within 72 hours.
That's
Then
the...
he can answer that he does not want to give an answer because it might tend to incriminate him. That's the prerogative of the party.
Your Honor, please, with the kind indulgence of the court, Your Honor.
Proceed.
What we are invoking is a right which is fundamental and enshrined under our Constitution, Your Honor. And it is the right of a person not to be compelled to testify against himself. Here, it is our humble submission, if Your Honor please, that the moment he is compelled to answer, he will state all his defenses and everything. And that is practically compelling him to answer. It is a definite violation of that particular law, not merely from being saved from the trouble of incriminating himself, but the right not to be compelled to be a witness against himself, Your Honor.
If I may make a counter
Well-
submission, Your Honor, please. Your Honor, please.
Let the witness answer, please.
All right. Again, I sound like a broken record, Justice Cuevas. Section 26 of the Ombudsman Act requires the Ombudsman to direct the respondent, in the event there's reasonable ground to investigate further, to answer within 72 hours. So I sent that letter requesting him. I want to emphasize the word requesting him. And so the knee-jerk reaction was, oh, the ombudsman has no jurisdiction over me. That's a phony data and all that. So now you're invoking the Bill of Rights.
I'm just stating for the record, Your Honor, the right, the constitutional right of the Chief Justice, Your Honor.
Already answered.
Yes, already. Now, I have examined the various affidavits of the different complainants in this case, and I have not find any statement to the effect that they are leveling an accusation against Chief Justice Corona for the amassing of this $10 million.
If
Do you agree with me?
Objection,
Yes, Your
Your
Honor.
Honor. The question
Yes,
is
Your
misleading. The witness has never stated that the basis for the $10 million accusation or charge is the 3 complaints. She has never said that. In fact, I do agree with you that if you examine the 3 complaints, there is no mention of the $10 million.
Thank you.
What she said is that the $10 million was gathered from information and evidence she got from AMLAC. So the question is
Objection
misleading,
sustained.
Your Honor.
Now, may I go back to the different complaints? Will you kindly tell the Honorable Court whether you have examined any of the complainants in connection with the contents of their complaint?
No, I haven't.
Not even any one of them.
No.
Now, there were statements by these complainants that they have nothing to do with the alleged $10,000.
10 million.
10 million, I'm sorry. I'm not accustomed to million also. Good lang ako sa 10 pesos. No. And they mentioned that they have nothing to do with that.
Yes, Your Honor.
Do you contradict that, or you are not in conformity with them?
That is correct. They did not mention anything about
Thank you,
$10
thank you.
million.
And insofar as their complaint is concerned, nothing is touched on the $10 million.
$10 million. No, Your Honor.
Now, this AMLAC that you mentioned a while ago, would you like us to believe that there was already a court proceedings involving the AMLAC?
No, Your Honor, I just asked for assistance if they had any document that had a bearing with the financial transactions
Yeah, but-
and related transactions of the Chief Justice.
But that will require an investigation, isn't it?
An
Or
investigation
inquiry
by?
the AMLAC. Otherwise, their statement to you in reply to your query may not be accurate and true.
No, I think the AMLAC law requires that if a deposit of 500,000 plus is received by the bank, they are mandated to report to the AMLAC these transactions.
But there is no statement here with respect to the AMLAC in coming in, and that the transaction is one covered by the AMLAC. Am I right?
No,
Misleading, Your Honor. The witness already stated that she requested the AMLAC for assistance.
Well, this is a different question now. I'm just asking him about the assistance. If Your Honor, please. I'm sorry.
Reform the question.
Now, my question to you is, there is nothing on record, nor in the complaints of the complainant here, dealing with that AMLAC intervention.
no, Your Honor, there's none.
There is
Precisely, I asked the assistance of the AMLAC because I wanted to know if there are documents in the possession of the AMLAC that have a bearing on the complaints.
Would you like us to understand then that the AMLAC can just come in upon the request of any...
Counsel, may I read to you the Constitution?
Yes, Your Honor.
Powers of the Ombudsman. Paragraph 5. Request any government agency for assistance and information